Okay, good morning. It is March 18th, and we're having a hearing basically on human trafficking slash prostitution. And we have a list of folks who've been asking to testify for a while now, and we're just going to start at the top of the list with Melissa. So, Melissa, if you want to introduce yourself, and the floor is yours.
Thank you so much. Good morning, everybody. My name is Melissa Bruto. I have been an attorney and advocate for sex workers and survivors of human trafficking, for an attorney for 20 years, an advocate in this space for 25. I'm here to strongly support Senate Bill 54, which would repeal prostitution laws relating to indiscriminate sexual intercourse, right? So it would fully decriminalize consensual adult prostitution while retaining laws related to trafficking and exploitation. Now, during my presentation, please feel free to interrupt me for any questions. I'm going to cover a little bit of sort of like larger picture sort of models, and then talk a little bit about some case studies. But please feel free to ask me any questions during this time, and I appreciate all of your time. So I have a joint JD and Master's in Public Health from Georgetown and Johns Hopkins School, Bloomberg School of Public Health. I entered into that program specifically to study the public health impacts of decriminalization of consensual sex work. That was 20 years ago, and I've been working in the field pretty much ever since. I spent about 10 years doing direct defense, primarily appellate defense of survivors of human trafficking, specifically vacating convictions, so clearing convictions of the records of survivors of human trafficking. I transitioned in 2018 to doing policy work. I'm the legal director and one of the founders of Decriminalized Sex Work. And we work in 5 states: New York, Rhode Island, New Hampshire, Vermont, and Massachusetts. So really New York and then parts of New England, of course. My perspective is always one of public health, right, and harm reduction. We, cannot legislate via morality, right? We have to legislate in terms of science, data, health, and safety, right? And also bodily autonomy, right, which is a really important tenet, I know, for folks in Vermont. And it's a really important tenet when we discuss sex work, right? So in terms of models around around prostitution, there's sort of 4 overall legal models, right? There's full criminalization, which is what every single state in the US has, right? With 2 exceptions, right? There's Nevada and Maine, but every other state, including Vermont, including New York, where I'm based, penal code criminalizing prostitution. Then there is the Nordic model or in-demand model, right, which would remove criminal penalties from, okay, sorry, the screen just shifted. Okay. Would remove criminal penalties from workers, but maintain criminal penalties for clients. And that model exists in Norway, Sweden, Northern Ireland, Iceland, and I know that Nina will speak about why those models fail to not only meet the goals of ending demand, but also fail to improve health and safety for sex workers. Then there's full decriminalization, which I am in support of and which this bill would enact in Vermont. This removes criminal penalties from all consenting adults. It would allow law enforcement to focus on trafficking and exploitation, which is what we want law enforcement to be focusing on, right? Not wasting time and energy arresting consenting adults, and also making it much more fearful for people to work, right, who want to work. Full decrim exists in New Zealand for, at this point, almost 25 years. Parts of Australia, Belgium just changed their model to full decrim. And many other states around the country are considering decriminalization. There's bills in New York, Rhode Island, Illinois, Massachusetts. There's been bills in Colorado, Hawaii. It's something that is is really in the ether because it is the right thing to do. And, I think that that is the direction that the US will head in, and many other countries we're going to see head in that direction, because that is really what will effectuate fullest autonomy and safety for people in the industry. Oh, okay. Sorry, I didn't. There's one thing. Then there is legalization, which is the last model. That is where sex work is permitted but highly regulated, right? So that exists in Nevada in the brothels, that exists in Amsterdam in the red light districts, and in some other jurisdictions. So I'm going to talk a little bit about public health data. First and foremost, decriminalization is a public health issue, full stop, right? And again, that's why I chose to, when I went to law school, to do a joint degree, because I knew that the public health piece was central to this conversation. Um, I want to point out two different studies. One is from my alma mater, Hopkins Bloomberg School of Public Health. They conducted a meta-analysis back in 2018 where they looked at 130 studies over around 30, I think 30 countries were involved. And they did a meta-analysis looking at all of this data, which is really important because people can always cherry pick particular studies, but it's really important to look at the full panoply of what we are working with, right? And it found that repressive policing, which includes either policing sex workers or clients or both, increased the risk of sexual and physical violence at the hands of clients, law enforcement, domestic partners. It also increased the risk of infection of HIV and STIs, and diminished the likelihood of the use of condoms. And repressive policing also disrupted sex workers' support networks and the ability to work safely, right? And that's something anecdotally, I've heard for over 25 years, right? When you are under criminalization as a sex worker, it is very hard to be safe. It's very hard to screen clients, to talk to other workers about safety, to, properly vet people to make sure they're not a harmful person posing as a client, right? The other key study I wanted to point out is the Rhode Island Study Commission. So back in 2019, I was part of creating a legislative study commission in the state of Rhode Island. And over a few years, it took longer because of COVID. So beginning in 2019 and then ending in 2023, when the final report was issued, there was a legislative study commission in the state of Rhode Island that included experts from across the field, and across the political spectrum, and reviewed data specific to Rhode Island, but also internationally. And what that commission ended up recommending ultimately was considering a law to restore Rhode Island to a pre-2009 landscape when prostitution was decriminalized indoors. And the reason they found that was during the time that Rhode Island had decriminalized prostitution indoors, there was a decrease in sexual assaults and in gonorrhea, right? And people were safer, people were able to work, people able to go to law enforcement and report. I mean, thankfully Vermont has immunity legislation, but it allowed people to work safer. It also proposed a series of partial measures, which Rhode Island is trying to enact, that thankfully Vermont has already enacted. Again, immunity, prohibiting police sexual violence of people in custody or people that are being investigated, right? So Vermont has already been at the forefront of this issue, thankfully. I want to quickly discuss some instances from when I was doing direct defense about how criminalization impacted my clients, right? I represented primarily survivors of human trafficking in New York City when I was at the Urban Justice Center for nearly a decade. And I had clients that some of whom had dozens and dozens, if not hundreds, of convictions on their record from prostitution that resulted from being trafficked, right? And I mean, in the 80s and 90s, policing was different, certainly in New York, where it was much more high volume, right? But my clients faced staggering collateral consequences of their convictions. They were not able to get employment, they were not able to get housing. They often lost their children or were barred from having custody or visitation in family court. And then, of course, immigration, right? We know, especially in this political climate, that protecting immigrants is paramount, right? And prostitution is a crime of moral turpitude when you in the immigration context. And so people are prohibited from obtaining status in this country, right? Unless they're able to go a few certain routes around getting a T visa or a U visa, but those are quite hard to get. So it really prohibits people from obtaining citizenship in this country. I had one client who was from Queens. She had 133 convictions on her record, all from being trafficked. She had an abusive partner, which is very often what human trafficking looks like, right? Despite what people see in movies, right? Human trafficking is most often an intimate, violent partner situation. Um, she was forced from quite a young age to engage in prostitution as well as theft. She had a few felony theft convictions that we were able to get vacated as well. Um, Her dream was to be a security guard in a building in Manhattan, and she could never obtain that dream because of her record. And we were finally able to clear all 133 convictions from her record, and she was able to work. Um, I also want to talk about a case of an Asian migrant worker, right? And again, in this current political climate, this is especially important. A woman named Yang Song, who leapt to her death in 2017. There was a police raid in Queens in her massage parlor, and she had already had abusive interactions with law enforcement. And so rather than engage with law enforcement again, she leapt to her death. And, her story is, has become a rallying cry, especially for Asian migrant women, I think throughout the Northeast. It's not just a New York issue. I see it, in the work I do in Rhode Island and throughout New England, where Asian migrant women are especially targeted by law enforcement around prostitution laws. And the consequences are so severe because of immigration. So I wanted just to conclude, that I wholeheartedly support Senate Bill 54. It is not radical. It is really ethical, right? It is really what would bring health and safety to sex workers and survivors of trafficking, right? We want to maintain all of the laws on the books related to human trafficking, which this does. And we want to remove penalties for consenting adults to make sure that people can work and work safely. And to also make sure that if people do not want to be there, they can engage with law enforcement, they can get services, they can exit, right? And so, it's time to repeal archaic laws, right? This was put on the books, I think, in 1919, indiscriminate sexual intercourse. And here we are, in 2026. So we really just want to ensure that people can be healthy and safe, right? And seek support when they need it. Thank you so much for your time. I'm open to any questions.
Thank you. Committee, any questions?
I'm wondering if you have any type of definition of what indiscriminate sexual intercourse or sexual activity even is, because my understanding is that goes beyond consensual adult sex work for pay.
Yes, my understanding is that the law, and this doesn't get to all of it, but that indiscriminate sexual intercourse refers to any outside marriage, right? Sexual intercourse. This bill would just repeal laws relating to prostitution for high, like indiscriminate sexual intercourse for hire. But the bill that it was attached to back in 1919 addressed and criminalized all sorts of indiscriminate sexual intercourse, even not for hire, which again, right, shows how archaic this is that we're talking about, right? Talking about adultery, which is not criminalized anymore, right? We're talking about sex outside of marriage, all of that, which again is clearly not something that is criminalized in Vermont anymore.
Well, it shouldn't be, but I think the way the law reads, depending on how you read it, it does still criminalize indiscriminate sexual activity.
Right. And, I'm not practicing in Vermont, but, certainly for, laws relating to whether it is sex between people of the same gender, sex outside of marriage, like all of, that can no longer be criminalized, obviously, because of Supreme Court cases. But again, it just sort of shows how archaic these laws are.
Thank you.
Yeah.
Any other questions? Okay. All right, thank you, Melissa.
Thank you so much for your time. I really appreciate it.
Very welcome. Next up, Savannah, slide.
See here. I share my screen. I have a brief slideshow for us.
Do you mind grabbing a seat in the?
Oh, may I? Is that okay?
Yep.
Thanks for your time today. My name is Savannah. I grew up in Vermont in Orange County. I've lived in Boston and Seattle over the years, but I've lived here for the past 5 to take care of my parents. I come to you today as a sex worker. I have been a sex worker since I was 18, so over 20 years. I have also experienced exploitation in the sex trade and I've witnessed sex trafficking. But professionally, I'm an advocate for human rights and I run a national nonprofit that supports the movement for sex workers' rights in the US today. So some of the data I'll be giving you today comes from having worked with hundreds of individual advocates and many, many organizations around the country. Today we're going to talk briefly about just the history of sex work in the United States. What is the movement for sex workers' rights? Who are sex workers? Some of the impacts of conflating sex work with sex trafficking. We're going to talk about discrimination protections and also the fact that sex workers exist in Vermont. So very brief history. We're going to kind of run through this. The first prostitution-related law in the US that I'm aware of is the Page Act of 1875. This was a precursor to the Chinese Exclusion Act. I've picked these moments in history to illustrate how people in the sex trade are also experiencing forms of discrimination outside of being involved in prostitution. The Page Act was specifically designed to prevent women from Asia from migrating to the US if they were suspected of being prostitutes. How were they determined to be prostitutes? Well, they were questioned extensively, men had to vouch for them, and they were the first people in the immigration process to be photographed at every step of the process. So we can see how racialized women who are assumed to be sex workers are being surveilled more than other people. So sex workers, people presumed to be sex workers, experience quite a bit of surveillance and also racism. More racist sex trade related laws, the White Slave Traffic Act, which is currently known as the Mann Act, it's still in the books. This made it a felony to transport any woman or girl for the purposes of prostitution or debauchery or for immoral purposes. And so this is where we start to see the conflation of sex work with sex trafficking, and it's deeply racialized. We see a poster here on the right. It's all about the hysteria of white females gaining more autonomy and independence, moving to the city to get their own jobs, and concerns about interracial mingling, essentially. So the idea that a white female would never choose to be with a black man, for instance, he must be trafficking her. That's where we get this law. And black men were the targets of this law. The Trafficking Victims Protection Act of 2000, this is where we get our first comprehensive federal law in the US to address human trafficking, both labor trafficking and sex trafficking. And so it defines sex trafficking as the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a person for the purpose of a commercial sex act, where the Commercial Sex Act is induced by force, fraud, or coercion, or where the person is under 18. And I bring this up because I think this is a great definition of sex trafficking. And as somebody who's experienced exploitation and witnessed trafficking and done sex work, I know the difference. And I feel like this definition helps us delineate consenting adult sex work with trafficking. And then most recently, the SESTA and FOSTA, which stands for the Stop Enabling Sex Trafficking Act and the Fight Online Sex Trafficking Act of 2018, signed into law, very ironically, by Donald Trump. This amended Section 230 of the Communications Decency Act to remove legal immunity for online platforms that host content that promote or facilitate prostitution. So what we did is, this is essentially a censorship law that made it very dangerous for people to host websites in the US where sex workers could advertise. So overnight, sex workers lost dozens and dozens of websites where we could advertise, and those websites are really important for us staying safe. They're also important for law enforcement to go on a advertising website. If they're looking for a missing person, law enforcement detectives would just go on these websites, look for the missing person, find a picture that looks like them, call the number, and you can go and find them. So law enforcement also lost these tools, and sex workers lost a way of safely advertising and vetting potential clients. Sex workers' rights in the USA. About over 100 years ago, we had our first sex workers' rights march in the United States. Over 300 sex workers marched to protest the imminent closure of their brothels in San Francisco. These workers, who were female, were demanding economic justice in light of wage gaps and lack of resources. They're like, if you want us to stop prostitution, if you want to take away our brothels, which are our homes, you can give us housing, fair paying jobs, and we need access to childcare. So sex workers are asking for the same things now that they were over 100 years ago. In 1970, STAR was founded in New York, and I uplifted this because we have Sylvia Rivera and Marsha P. Johnson, who are two icons for trans rights, LGBTQ rights in New York. And they started STAR to bring in homeless transgender youth in the 70s in New York, because they knew, as trans women themselves, that queer youth get kicked out of their homes by discriminating parents, and these youth try and survive in the sex trade, and that's a form of sex trafficking. But sometimes youth have to make that hard decision to support themselves, especially when they face discrimination. So this is an example of how sex workers, these two women, Marsha and Sylvia, used their own sex work money as adults to help support youth so that those youth did not need to engage in the sex trade. So this is sex workers understanding how to stop sex trafficking, right? Because we care, we see sex trafficking, we want to stop it, and we know how this works. In the late 70s or early 80s, the Scarlet Harlot, seen on the right, Carol Lee, coined the phrase sex work. It didn't exist before then. And she coined it to frame prostitution as a labor issue. This is a job we're talking about, it's sex work. And to also have a counter to dehumanizing phrases used by second wave feminists like the sex use industry, which remove all agency from people who are engaging in prostitution. And then, as my colleague Melissa said earlier, illustrating how attempting to raid and rescue people from presumed trafficking can lead to a lot of harm. Yang Song in Flushing, New York, jumped to her death from her apartment when her apartment was raided for the second time by police who were there to stop sex trafficking. So that's a brief history. But what is the movement for sex workers' rights? Well, I think it kind of started in the US with those 300 sex workers marching in San Francisco. But this is a little data about how this movement is rapidly accelerating, and for good reason. In 2015, I was at Sex Workers Outreach Project USA, and we counted about 30 visible sex worker rights organizations in the US. These are organizations led by people with lived experience in the sex trade. There's about 30 of them. Now my organization, New Moon, in 2025, we can count nearly 300 sex worker-led organizations. And these organizations are advocating for the decriminalization of sex work, which is what we're doing here today. They're also providing services to their communities, much like Marsha and Sylvia were trying to protect trans youth. So sex workers are trying to protect themselves and change the laws that are affecting them. And my organization has provided resources to nearly half of the organizations that you see on the right. We talk to these people every day. We know who they are. Why are sex workers mobilizing? They're criminalized, they're highly stigmatized, and they often faced racialized or gender-based discrimination or class issues. So why are they coming out of the woodwork to say we exist and we want society to talk with us? There's been an increasing conflation between sex work and sex trafficking. Efforts to abolish the sex trade, to stop sex trafficking, have led to increased danger and instability for sex workers. And I can say this for myself. I've experienced this. I became an advocate about 13 years ago because in Seattle, I was experiencing some of these things that were happening to stop sex trafficking. Increased policing, raids on your home or workplace, increased penalties for working together or for our clients. Increased surveillance, such as facial recognition technology was sort of trained on sex worker advertising sites with data scraping. We get surveilled left and right. Increased discrimination in banking, housing, and child custody. On the right, we have a chart here from Free Speech Coalition. They're the trade association for the porn industry. And they say 63% of people working in the adult industry have lost a bank account or financial tool due to their work. And when you lose access to your bank account, it doesn't mean that you don't use money anymore. It means you have to rely on somebody else to do your transacting, and that can lead to exploitation. All of these things increase instability in somebody's life and actually increase the odds that they will be exploited by another person in the sex trade. Increased censorship, being removed from the internet, not being allowed to exist on the internet or in public. Decreased laws for tools for law enforcement to investigate missing people. I mentioned that earlier. And then the erasure and discrediting of sex worker existence. Sex workers understand sex trafficking because a lot of us have experienced it. It's really hard to stay safe when you can't tell people what you're doing, when you're afraid of being arrested, when you're afraid of having a safe place to work. You don't want anybody to know what you're doing. You're very isolated because of criminalization. And also people want to make money off of us. And if we can't build community or talk to each other or understand what's right from wrong, it's like sex ed, you know, it's like understanding if somebody's hurting you or exploiting you. You don't know that unless you have that education. So a lot of us have experienced exploitation, and I think it's because of criminalization, but we decided to ask people in our extensive network. We asked 20 organizations that we work with, how do leaders in your organization identify as sex workers or survivors? 19 of the organizations said that their leaders identified as sex workers, and 16 said that their leaders identify as survivors. And we're like, oh, we didn't really quite ask the right question. We're not researchers. Does this mean that sex workers and survivors are working together as leaders? We know that that does happen. Or are people saying that they have both experiences? So we asked the question again to individual program participants in one of our leadership programs. And on the right, we asked, how do you identify as a sex worker, a survivor, or both? And we see that 7 out of 21. Oh, I got that math wrong. Ignore that. Anyways, the graph is proportionately right. The numbers are wrong. My apologies. But a lot of us have both experiences, is what I'm saying. And we still are advocating for the decriminalization of sex work. And also sex workers are central stakeholders to identifying and stopping exploitation in the sex trade. We know how it works. Sex workers also have other identities and life experiences frequently that make life challenging. And a lot of people choose sex work for a variety of reasons, maybe due to discrimination or disability. Like we see here, we asked 21 program participants whether they were low income, disabled, or housing unstable. And again, I apologize here that the numbers are not matching 21, but this is proportionally correct. Of our 21 participants, the vast majority of them said that they were low income. About half of them said that they were currently housing unstable. And then I would say maybe a sixth of them said that they were living with a disability. About half of them identified as being people of color. A lot of them identified as being cisgendered females, and a little less than half identified as transgender or gender nonconforming. So we see this kind of pattern with these demographics all over the sex trade in the United States. A lot of LGBTQ people, a lot of females, a lot of people of color, and people who are struggling to make ends meet. People do sex work to make ends meet. I understand that Vermont is advancing a constitutional declaration of rights right now. That's really great. And it would provide equal, it would mean that everybody gets treated equally despite their race, ethnicity, sex, religion, disability. This is great for sex workers because as we can see, sex workers have a lot of identities that can be discriminated against, you know, people of color, women, queer people. And this is an opportunity to extend that to sex workers or to consider sex workers as people who experience discrimination. We have another statistic down here from Free Speech Coalition that 3 in 5 adult industry performers, porn stars, have experienced employment discrimination. So how can you move on from sex work if no one will give you a job, right? it kind of traps people in the sex trade. And then 2 out of 3 performers have had experienced housing discrimination. People will not rent to a known sex worker based on moral grounds alone. And there are actually sometimes laws on the books, that prevent sex workers from accessing housing. But in Victoria, Australia, where sex work is decriminalized, they actually have the Equal Opportunity Act. It recognizes, it's very much like what Vermont is considering right now, but it recognizes sex workers as disproportionately LGBTQIA. A lot of LGBTQ people get involved in the sex trade because of discrimination. And so it includes sex workers specifically in their Equal Opportunity Act. And they say that nobody can be treated unfairly due to their occupation, their current occupation or their prior occupation. And sex workers in Victoria, Australia have successfully used this to sue current employers who fire them when they find out that they used to be a sex worker. And this happens to sex workers all the time. They lose their jobs when they're like, oh, you were a stripper 20 years ago, you're fired. You're not the right kind of person. But in Australia, in Victoria, Australia, you can't do that. And also sex workers in Vermont exist. I know this might not seem like a relevant issue. I'm a sex worker. There are other sex workers in the room. And I pulled a little data for us. Last Friday, when I was preparing this presentation, I decided to count how many people I could see advertising sexual services in Vermont. I counted about 90 on 3 different websites. That's just 3. I'm sure there's more. I estimated that about a third of them live in Vermont, either part-time or full-time, just kind of glancing through profiles. I personally know 10 other sex workers in Vermont who are not advertising right now. And then also Ishtar Collective, our local sex worker rights organization, they hosted a summit a little while ago that over 100 people attended, overwhelmingly sex workers and some allies. So sex workers are in Vermont. It's likely that there are hundreds of online sex workers in Vermont. These are people who are creating adult media, which we also call pornography. They're performing on live shows, or they're offering phone sex. And there are going to be more and more people turning to sex work as things get more economically difficult in Vermont and elsewhere. And we have a little bit of data, which is that during the onset of the pandemic in 2020, online sex work shot way up, way up. So OnlyFans, which is one popular online sex work site, they reported a 75 increase in signups of people wanting to sell adult media for money in the early months of the pandemic. 60,000 new creators joining in March of 2020 alone. That's one platform. That's 1 month. And all these people are now technically sex workers who can face child custody being jeopardized, have their kids taken away. They have deportation issues, housing issues, intimate partner violence, and discrimination on the workplace. So sex workers exist in Vermont. There will be more of us. Thank you for listening. And I'm open to any questions.
Thank you. Maybe any questions? Thank you.
Thank you.
And next up, we have Nina, and I don't want to mispronounce the last name. Nina, can you hear us?
Oh, whoops, sorry.
I can, yeah. I don't know if we should take the sharing of the presentation off. Oh, yeah, thank you. Thank you everyone for listening, and thank you Melissa and Savannah for the great introduction to the topic and the legislation, and also kind of the experience of sex workers and survivors and how they often interlap. And I also want to thank the committee for considering this bill that will directly affect the safety, health, and lives of sex workers and survivors in Vermont. So I think you're at a very important decision here. So I just wanted to say a few words about myself. So I'm an assistant professor of international migration at London School of Economics, and currently a visiting scholar at NYU. I have over 10 years of experience of researching sex work and trafficking. And in my work, I have especially focused on the so-called Nordic model that claims to shift the focus away from sex workers and survivors by criminalizing the buying but not the selling of sex. And I did extensive research on this topic in the Nordic region. I carried a 3-country study, one of the largest studies on the topic, and I interviewed over 200 people, out of which majority are sex workers and survivors. And of course, as part of my my research and academic career, I have also read extensively on different policy models, and that's what I'm here to talk about. So I wanted to first say that my testimony will really much focus on the research, and I think it's really important when it comes to sex work and trafficking to look at research and evidence, because in this area policies are too often guided by moral arguments than what the data actually shows us. And I'm in strong support of this decriminalization bill, because if we look at the international research, the evidence is clear that full decriminalization represents the global best practice. Leading medical and social science journals such as Lancet has demonstrated that decriminalization improves health, safety, and rights outcomes for sex workers and survivors. For example, studies have established that if decriminalization would be adopted as a global approach, HIV infections would reduce from 30 to 46% globally in the next 10 years. So we can see that it has massive health impacts for sex workers. Of course, it also is very important for the safety of sex workers, which has been already said. Decriminalization brings rights to sex workers and survivors and improves relations between sex workers and law enforcement. So when you're no longer criminalized, you can turn to police and officials in the case where you're exploited. And this is also a very powerful tool against criminality and trafficking. So when sex work is decriminalized, criminal associations become unnecessary. So it reduces association with criminality and sex work. And sex workers and survivors are empowered to turn to officials knowing that they will be protected and not criminalized by the law. And we have a lot of evidence on this, especially in New Zealand and in Australia, where full decriminalization has existed since the 1990s. It's also important to mention that full decriminalization does not increase the sex trade. So evidence from Australia, especially New South Wales and New Zealand, both which have had a full decriminalization since the 1990s, show that there has been no increase in the sex worker population. Studies also show that a number of sex buyers have not increased. And for example, in New South Wales, one of the Australian states with decriminalization, 2.3% of men reported paying sex in the last year. And this is also in accordance with the broader Australia that has different legislation. So we can see that the decriminalization does not increase sex buying or the number of people in sex work. And importantly, decriminalization has the potential to reduce trafficking and exploitation because it reduces the structural conditions that enable trafficking. It reduces the profitability of illegal operations and creates conditions where sex workers are more likely to report exploitation to authority. So we can see clearly kind of the benefits of decriminalization for the health, safety, and kind of reduced criminalizations or criminal associations of commercial sex. One thing that hasn't been mentioned is that it can also reduce stigma related to sex work. And studies show that stigma is one of the main contributors to violence that sex workers experience. So, for example, in New Zealand in 2018, Catherine Healy, a sex worker activist that was crucial in campaigning for the sex work decriminalization, was made Dame in the Queen's Birthday Honours list. And this is about like 20 years after the decriminalization was accepted or adopted in New Zealand. And this tells something about how sex workers can be seen as valuable contributing members in society when stigma that comes with criminalization is reduced. So so we can see clearly the benefits of full decriminalization. I also wanted to talk about different types of criminalization and the harms that they cause. And I wanted to especially focus on the so-called Nordic model or the end-demand model, because it's heavily present in policy discussions and often offered as a kind of alternative to full decriminalization. So as I mentioned earlier, I conducted vast research on this topic, and my research, together with studies on other jurisdictions such as Canada, Northern Ireland, and France, demonstrate that even if this model claims to move policing away from sex workers and survivors to sex buyers, it does not happen in practice, but sex workers are still the main target of policing and also bear the biggest burden of the law's negative consequences. And I will outline the negative consequences very shortly here. So first we can see that partial criminalization increases violence against sex workers and survivors, and this effect is worst for the most marginalized, those working on the street, migrant sex workers, indigenous people, and people of color. And kind of the reason is concrete, like when clients fear arrest, they refuse to share personal details, rush street interactions, and increasingly demand in-calls, which means that sex worker goes to the locations of clients choosing instead of their own, which is always more dangerous for sex workers. So in other words, it diminishes the ability to sex workers to protect themselves and to screen clients. And if we look at the studies through different jurisdictions, they have the same results, and these findings are drawn from studies that have very high number of sex workers survived. So from 2,000 to 600 sex workers and survivors surveyed in Canada, France, and in the Nordic region. Secondly, we can see that the Nordic model consistently leads to the police to prioritize reducing sex work by any means available. For example, in the Nordic region where I conducted my research, as well as in Canada, we can see how this has led to the use of other laws like third-party so-called pimping laws, and migration laws to evict and deport sex workers as a way to kind of reduce the numbers of people in commercial sex. So the overall picture that we see is a punitive environment targeting sex workers and survivors rather than sex buyers. And this, of course, increases violence and erodes trust in officials, making it harder to report crime and exploitation. Also, in my experience, perpetrators know that sex workers are unlikely to report violence and exploitations, and that's why sex workers often get targeted by these people who mean harm. So often kind of the Nordic model is kind of marketed as a way to reduce the levels of sex trade. However, there's no studies that would demonstrate that it would deliver on its central promise of reducing the sex trade. At points, the street-based sex work has declined because it's the easiest to police. But we see that this is rather a displacement, not reduction. The trade moves online and indoors, becoming less visible. There's no evidence from any jurisdiction that sex buyer criminalization would reduce trafficking or pimping. My own study found the opposite, that this kind of punitive policing targeting sex workers' working locations forced many sex workers instead to turn to exploitative third parties to secure a place to sell sex. Finally, we can see that the promised social services and exit programs have not materialized in any accessible form in any jurisdiction where this model has been adopted. And where they do exist, they are often insufficient and conditional on stopping selling sex, which many cannot afford. And I'm happy I compiled this comparative research summary, effects of sex buyer criminalization laws globally. I'm happy to share it with the committee, as well as a policy brief that summarizes my research findings, so you can look more into detail these, and so I can share them after I finished. So just to kind of summarize, we can see that there are no benefits to the Nordic model. It increases the vulnerability of sex workers and survivors and exposes them to violence. On the contrary, we can see that the research shows that in fully decriminalized environments, we see clear improvements in health, safety, and rights, increased trust in officials, greater reporting of crime, and no increase in the sex trade. So the committee here has an opportunity to make Vermont a place where the evidence guides policy and where the well-being of sex workers and survivors is placed at the center of decision-making. The research and human rights community is unambiguous. Full decriminalization is the best global approach that protects the most vulnerable and reduces criminal involvement in the industry. Thank you.
Thank you, committee. Any questions? Thanks again. Next up, Henry.
I apologize. If we go over a few moments, but I wanted to start by thanking you all for your time. There are a lot of experienced advocates and experts who have worked directly with my community. And over the past 6 years, members of our community have lived and died under criminalization and stigma. So even in small states where these numbers can't be big enough to be sensationalized, and where data might not be attractive to our own moral compasses, even giving us this opportunity to speak truths means so that our friends who aren't here with us today aren't forgotten in legacy, and that their work meant something. Thank you. So without further ado, my name is Henry Banks. I'm a retired consensual sex worker for more than 10 years. I'm the co-founder and co-director of Judiciary Collective. We're an anti-trafficking and sex worker rights organization based out of Vermont that reaches far over the East Coast now. We were established in 2020. We work in policy and direct services with trafficking survivors in the Green Mountain State. In 2020, a bill to decriminalize sex work was already introduced before our collective was named and formed. But that same year, we were born. Our membership got together. Members collective being sex workers and survivors, as I mentioned. We coined the name in our first meeting, and we decided this organization was needed in order to put sex workers in the room where policy conversations about us are happening, because we're stakeholders too. We wanted to make sure legislators knew this bill was needed and that sex workers live here in Vermont and that they care about their futures enough to advocate for their rights and their safety. The pandemic did show us that even in the most dire times, sex workers can be left out in the cold with no help from the government. For us, that manifested in the federal stimulus program. Many sex workers were written out, even 1099 tax-paying contractors. You'll find that most strip club employees can be identified in their tax files as 1099 private contractors, not employees at all. So folks like that were written out of the stimulus program. That means that those really, really helpful $2,000 checks that would have made or broken people's housing access, healthcare access, etc., they didn't get those. Sex workers in Vermont rallied together. We gleaned produce and started our own food distribution garden that is now grown and delivered over 4,000 pounds of produce, not just to sex workers, but all kinds of struggling families in central Vermont. And from there, we've expanded our direct services to include a health referral clinic where sex workers and high-risk members of the community can find non-discriminate health care if they don't have insurance, access to safe STI testing, therapy, HRT, etc. through our program. We also have 2 active partnerships with 2 separate churches in central Vermont in expansion of our food distribution program. One being the Church of the Good Shepherd in Barrie that helps us host our hot meals once a week on Sunday from 4 to 6. I'd love to see any of you there. It's come as you are kind of thing. And then also our community fridge program in the Montpelier Church, the Universalist Church that's there on State Street next to the liquor store. But the stark reality of our second-class citizenship became real in the pandemic. When we realized we needed to organize not just for policy conversations, but for our own well-being. We established our food distribution garden, as I said, and many members of the community saw sex workers rising up as the good, considerate, caring, and big picture thinking neighbors that we are. Aside from our direct services, we have worked hard with policymakers since 2020, starting here in Vermont, to protect the lives of sex workers and survivors alike. We don't care how you identify. We want you to survive, right? We want you to be safe. And to further the rights of sex workers as well. Vermont's legislature has shown us that there is real care and recognition for erotic laborers in the Green Mountain State. Over the past 6 years, that recognition has manifested itself in a couple really important incremental measures that I would love to kind of go over with y'all. Some of us were working together at that time. Some of us are meeting for the first time. In 2023, the legislature enacted a law prohibiting law enforcement from engaging in what you would call investigatory sex, which, along with the state's already existing prohibition on custodial sex, comprises the country's most comprehensive ban on police sexual violence. And I'm proud to say that sex work advocates were a part of that process. In 2022, a ballot referendum approved by the governor removed a ban on prostitution from the city charter in Burlington. And not only was this passed by Burlington's municipality, but it was signed by Governor Phil Scott. Again, it builds confidence in the sex worker rights community in the state of Vermont. In 2022, there was also a ban removed on prostitution in Montpelier. And there we saw our own city council stand in our defense of the sex workers that they could identify from our disaster relief program and our policy actions we passed. Again, trust in good neighbors, In 2021, an immunity law that's been referred to a couple times in this hearing, H18, was passed. It allows sex workers and survivors of trafficking to seek police assistance for medical care should they be witness to or victim of a crime without fear of arrest. And this was enacted with the House passing this unanimously, no debate. But under criminalization, we still don't see the same protections as other workers and citizens. We face discrimination, stigma, and arrest in many day-to-day circumstances, where a lot of other people just don't. Excuse me, I apologize. I'm sorry, I lost my place. I've had my own labor history recognized against me, unfortunately, by a stalker who followed, harassed, publicly pursued not just me, but like my neighbors, my coworkers, and even other members of the collective for over a year. And my ability to seek legal avenues of protection were cut off at the knees by stigma named in a doxing that happened to me in public. And it created a sort of doubt that led to the refusal of an RFA. And my stalker was never held accountable. Not a single time. In the last month, 4 Ishtar collective members have told me stories also of stigma being used in person-to-person conflicts to intimidate and silence members of my community. And if criminality did not impact the situation, perhaps then my friends would feel safer looking for support through the legal system. And again, maybe my stalker would have met real consequences. The people I know who have had their experience in sex work weaponized against them aren't victims, though. This is not a call to infantilize us in the name of denying us rights. We are self-empowered, autonomous people for adults. What it is, though, named to do is to point out that even with immunity passed and the incredible incremental changes that we've trailblazed together over the past half decade, criminalization still impacts us day to day. That is not just a risk, it's a reality, and thus it's relevant to the population of Vermont, a community-driven, small do-it-yourself state that doesn't need big, impressive numbers to make the right decision. This is another opportunity like that. Vermont has been a trailblazer in making hard, not feelings-based, but facts-based policy decisions for as long as I've been familiar with the state. It informed why I chose this state as my home place. More than that, Vermont has an opportunity, as you've heard, to join a growing movement that is calling for the rights of sex workers. Also, globally, research demonstrates that decriminalization increases public health and safety, decreases violence and exploitation. You can see endorsements of this policy from the World Health Organization, the ACLU, Amnesty International, the Human Rights Campaign, the UN Group on Discrimination Against Women and Girls, UNAIDS, the Freedom Network. They all call for the decriminalization of adult consensual sex work to combat trafficking and the transmission of HIV. Evidence from closer to home reflects this too. You heard a mention of a study commission that took place in 2019 and concluded in 2023. I was also a part of that study commission. And many stakeholders from a spectrum of experiences, from law enforcement to state health commissioners, were all part of this study commission that took place was active for more than 6 months. These were our conversations that compounded themselves over a number of years that resulted in these recommendations to decriminalize from this neighboring state. When it comes to human rights, I really do believe that Vermont's policies should be informed by on-the-ground needs of people most affected. And we see in our work that decriminalization is the next step to improving the lives of survivors and workers alike. This facts, not feelings-based policy says Vermont makes hard, but responsible and big picture decisions for state's shadow community members who so need fair access to resources, outside labor, and safety like every other laborer. Sex workers should be able to access housing and healthcare without discrimination. They should not have to worry about losing custody of their children because of how they support them. They do deserve, just like everyone else, to live in a community where their labor doesn't inhibit access to other forms of labor or any basic resource needed to sustain life. We deserve to live freely with safety and dignity. I really thank you for your time and consideration on this matter. I'm absolutely open to answer any follow-up questions with the remainder of our time.
Thank you. Any questions? Okay. Thank you.
Thank you.
Switching gears now to H 849, and we have Hillary here with us.
Good morning.
Do you need the screen?
Yes. Well, just for anyone who appreciates the visual. Slide.
There it is. Erase this. So it's hard to get through.
Where? Yeah. just so you just. Right.
No, no.
You just need to let it.
Yep.
Sorry.
Thank you.
Yeah. Coming y'all.
Good to go.
Yes. Good to go.
All right, for the record, Hillary Trevor Ames for the Office of Legislative Counsel. And this morning, I have a couple slides, just kind of context that I used with past Judiciary on H49, and then we can move quickly through the so I'll touch on 5 things: what a cause of action is, what is in existing law, what H849 proposes to do, what other states are doing or have done, and some questions related to whether states can do something like this. So a cause of action is permission to go to court. You have a right, but unless you have permission in some source of law to enforce it in court and ask for some kind of relief, then you can't go to court and ask for anything. So cause of action generally specify who can sue, who they can sue based on what conduct, and what they can ask the court to order. 2 pieces on kinds of relief. Damages, monetary damages, can compensate someone for harm that happened in the past or deter future unlawful conduct. An injunctive relief is an order to do or stop doing something. Cause of action comes from either recognized by common law, legislators can create them in statutes, and courts sometimes infer or imply cause of action. That's generally so existing law, there is not a Vermont state or federal statute creating a cause of action for damages against federal officials for violating the US Constitution. H849 is based on a federal statute, 42 section 1983, which creates a cause of action for damages against state and local officials for violating the US Constitution. But section 1983 does not cover federal officials at all. There is some case law. So the US Supreme Court has inferred a cause of action for damages against certain federal officials for violating certain federal constitutional rights. But it's very limited to a certain number of factual scenarios. So what H849 proposes to do, insofar as it creates a cause of action against state and local officials, it is a parallel to the federal law, section 1983. But in adding federal officials, it is doing something that is not available under current state or federal law. We're going to interrupt at any time with questions, otherwise I'll keep moving. So H849 would create a cause of action for damages against state, local, or federal officials for violating the US Constitution, who can sue any citizen of the state of Vermont or other person within the jurisdiction of Vermont. They could sue every person who, under color of any statute, ordinance, regulation, custom, or usage, subjects or causes to be subjected any resident, a Vermont resident, or any person in Vermont to the deprivation of any rights, privileges, or immunities secured by the US Constitution. Under color basically means when acting in official capacity. So it's not any person, it is a person who has an official capacity, is a state, local, or federal official, and the conduct is within that capacity. What kinds of relief are available? Both monetary damages and injunctive relief could be available under H849. Other states, there are some examples of existing laws in a number of states that are a little bit different from H 49, but that have kind of broader language, creating cause of action for violations of constitutional rights. Generally, those laws pertain to a certain kind of violation when threats, intimidation, or coercion are used, but they are a law that create the cause of action that is available against a federal official. For bills that are more similar to H 49, there are a number of states considering them. California, New York, I think other places you might hear from could give you other examples or more details, but some states are considering bills like this. I'm not aware that any have passed, with the exception of Illinois. And Illinois' law, the Illinois Bivens Act, is narrower and a little bit different than H 49. It applies only to suits against people who are acting, I guess it's the conduct while conducting civil immigration enforcement, knowingly violate the state or federal constitution. So as just using language of H 49, that is not a narrowing piece of H 49, but that's a main difference with the Illinois law statutes.
So I'm curious about, and maybe you'll be getting to this eventually, but just sovereign immunity in general. How would we be able to create a statute that allows a citizen to sue an official in the federal government if the federal government is not explicitly said, under these circumstances, you can sue us, unless there's the intentional misconduct piece to get through the sovereign immunity?
So generally, sovereign immunity applies to suits where, if you're talking about United States sovereign immunity, where the United States itself is named a defendant, there are lots of areas of law where the kind of workaround to sovereign immunity, something that doesn't trigger sovereign immunity, is if you sue a federal official in their official capacity. It seems odd because in many cases, or it might seem odd because in many cases, it is still ultimately the federal government that will indemnify an individual officer. So it is still, in a way, the federal government paying, but suits against individual officials don't trigger the sovereign immunity concerns that suits that name the United States as a defendant might. So a first level answer, happy for follow up, and I can also follow up with the committee with more details on this too.
Yeah, I think, I know that, hypothetically, the head of DHS could get sued and, in a certain situation, depending on the facts, but if somebody were to try suing, the head of a local DHS office or even individual officers, in any federal office in the area, can you describe how that would work and how that would be different rather than suing the head of the agency?
So the difference between suing an individual officer and the head of an agency?
Under this statute.
Under the statute. So under the statute, there would not be a difference between those suits necessarily. The cause of action would be available if any of those individuals allegedly violated constitutional rights. There might be factual differences between the kind of claim against the head of an agency and an individual official. There could be a kind of supervisory argument with relation to the head of an agency, but without going fully down the rabbit hole of possible differences in the facts, the cause of action would be available against either. So sovereign immunity gets triggered when you sue for money damages, but it does not create a concern when you're suing an individual official. There are other, and we can move forward to those. There are other supremacy clause related questions with a bill like this, but that's distinct from sovereign immunity.
Senator Bose.
Yeah, so two questions, although it looks like one of them might be answered. And so one of my questions is, if there is a constitutional or supremacy clause reason why we are defaulting to only the US Constitution being violated and not the Vermont Constitution being violated.
So there are a couple of issues that would arise if HA 49 also included violations of the Vermont Constitution. One is that enforcing or creating a cause of action that allowed suit against a federal officer for violating a state constitution likely raises some supremacy clause concerns for which there are not necessarily strong arguments. One other reason that is separate from supremacy clause concerns is the Vermont Supreme Court has implied causes of action under certain provisions of the Vermont Constitution. So there is an existing body of case law such that individuals in Vermont can sue at least state and local officials or persons for violating particular provisions of the Vermont Constitution. And if the bill included Vermont Constitution, it would kind of displace that case law. And I think some of the considerations involved in that were, if that case law is working, is right, is nuanced based on the Vermont Constitution, fully displacing it by adding the Vermont Constitution to HA 49 might create more challenges. But those are at least two considerations for, I think, why decision makers related to this bill did not include the Vermont Constitution.
Okay, that's helpful. And then my other question is, so you said that the Illinois law is much narrower than this, but my concern with the Illinois law is that it might be deemed as discriminatory against the federal government, whereas this applies to everyone. So does that make this stronger than the Illinois law in terms of defensibility?
So it's a great segue into some general questions of defensibility. Committee is very familiar with intergovernmental immunity at this point, and there's both direct regulation and discrimination. You're correct, Senator, that the Illinois law, so the US government the federal government has challenged the Illinois law. Briefing is still ongoing, so we don't have a decision yet. But one of the arguments they make is that the Illinois law discriminates against federal officials because effectively the people generally doing civil immigration enforcement are federal officials. You're correct that HA 49 does not raise that discrimination concern because it applies to state, local, and federal officials. There are other arguments that the federal government, can't say arguments, in their complaint, some of the issues that have come up in the federal government challenge to the Illinois law would still apply to HA 49. So in terms of direct regulation, and here I think I can't predict what the court will do. This is generally an unsettled area of law. There are scholarly and judicial opinions and arguments on kind of both sides of whether states can do this on each of these issues. So I can kind of offer what issues might come up and some of the arguments involved. And then I think other witnesses will be positioned to offer kind of their predictions or expectations of what might happen. On direct regulation, I think the arguments are that in creating a cause of action that would allow people to sue federal officials for damages, for money damages, it could affect their conduct because they are scared about ending up sued, and that effectively changes their conduct in a way that constitutes direct regulation of the conduct. I think the flip side is that just creating a cause of action that enforces what federal officials are supposed to be doing anyway, which is following the US Constitution, is not necessarily direct regulation. So intergovernmental immunity might still come up, but there are kind of arguments on both sides of what that might look like. On federal preemption, generally are asking, has Congress in a federal statute either explicitly said or suggested that a state can't pass a law like HA 49? And I'll just flag two federal statutes that are relevant here. The Federal Tort Claims Act allows individuals to sue federal employees for negligence or wrongful conduct in the course of their employment. It provides a very specific structure. The Westfall Act then says, if you are suing a federal employee for negligence or wrongful conduct, you have to do it through the Federal Tort Claims Act. You can't do it through any other kind of action. So one argument is that under the Westfall Act, if a state has a law like HA 49 would be, then the Westfall Act basically says you can't use that against a federal employee because Westfall Act says you have to use the Federal Tort Claims Act. The argument on the other side is that a constitutional violation is not necessarily considered a negligent or other tort, right? There's a difference between there are differences of opinion, but you can argue there are differences between at least certain constitutional violations and the kinds of conduct that would be covered by the courts of the Federal Tort Claims Act. There's also an exception to the Westfall Act saying that the Federal Tort Claims Act is the only way to go. The exception says that the exclusivity of the Federal Tort Claims Act does not apply to suits for violations of the Constitution of the United States, the U.S. Constitution. Not exact quote, but so the argument there is that that exception preserves other causes of action, specifically for violations of the U.S. Constitution. I think there scholars differ, and some judges have had a few not binding, but some opinions on that question. Some say that just pertains to those. I mentioned the Supreme Court has implied some causes of action. Some folks say that was just meant to preserve that implied cause of action. And some say that that still could allow a law like a state law like HA 49. So those are some of the potential issues that could come up either in a facial direct challenge to the law or in a case where someone brought suit under the law against a federal official. They could be raising some of these arguments in defense. So happy to answer any questions. Otherwise, I will briefly touch through the sections of the bill and then
That sounds good. If there's any other questions.
we'll stop sharing. So HA 49 on page 1, line 8, lines 8 through 16. This is subsection A. Or I guess I'll take a step back. This would create a new chapter and a new section in Title 12 of the VSA. The chapter would be deprivation of constitutional rights. A new section 5797, civil action. The reason behind creating a new chapter, creating a new cause of action is something that you'd want people to be able to find easily when they are looking through the VSA. And so instead of adding a section underneath another chapter that doesn't clearly pertain to the topic, this is a way of really identifying where this is. So lines 8 through 16, subsection A, this is everything that we just talked about on the slides. The language of this is not the most clear. An easier way to say this would be, these people may bring an action against these people, but this language matches the language of the federal statute, section 1983, with the idea being we're directing a court, the bill's directing a court to look at that body of case law in deciding how to interpret this section. Line 17 through 20, subsection B, clarifies that under color of any statute, ordinance, regulation, custom, or usage, includes any statute, ordinance, regulation, custom, or usage of the United States and of any U.S. state or territory for the District of Columbia. And that's clarifying that subsection A is applying to state, local, or federal official for action taken by a state, local, or federal official. On page 2, lines 1 through 5, subsection C provides that any defense available to a defendant under section 1983 is also available to any defendant in an action brought under subsection A of this section. So that includes qualified or absolute immunity defenses, but it is not necessarily limited to those. Any defense that could be raised in section 1983 suit could be raised by a defendant in an action brought under this section. The second sentence that this subsection does not alter, amend, create, or support a qualified or absolute immunity defense in any other action or proceeding brought under any other provision of Vermont law specifies that preserving qualified or absolute immunity here does not suggest that qualified immunity is available elsewhere. So it's not codifying qualified immunity in Vermont law. It is other than saying that it is available just for costs of action under this section. Finally, on page 2, lines 6 through 8, subsection D, this specifies that the intent is that courts construing this section will be guided by the construction of 42 U.S.C. section 1983 as amended and as interpreted by the courts of the United States.
Just wondering there, and maybe this is a standard practice that would be unobjectionable to the courts, but would this strike the courts as separation of powers where we're guiding their construction?
So this is modeled off of 2 existing statutes, so it's not an entirely new thing to put in a bill. The way that it does not necessarily trigger separation of powers concerns is that the court's role in interpreting a statute is to give intent to, or give effect to the intent of the legislature in passing it. So this is more of a tool to give the court to say, in writing this, we are intending that it carry the meaning of section 1983. Like we're intending to bring in section 1983 case law and have it operate that way. It does say guided by, not bound by. I think bound by might raise that kind of separation of powers concern that you mentioned, but the way this is phrased, it is providing that extra tool to a court in doing what the court is supposed to be doing and what the court does in interpreting a statute to say that the intent of the other language is to bring in how section 1983 is construed. Finally, page 2, line 10, the effective date is July 1st. So happy to answer any other questions, otherwise I know you have other witnesses lined up.
Thank you. Any questions? Great, thank you very much.
Okay.
I know, actually, Zone A had asked to go next, just due to some time constraints, and then we'll get to you next. Judge Zone A, welcome.
Thank you. Good morning. And I thank you for taking me out of order. I'm going to head back up to House Judiciary in a moment. Tom Zone, Chief Superior Judge. This will be short, and I'll give you what I told House Judiciary. This is a policy bill. It involves a lot of questions about interpretation of law, so I really can't offer much there. As Ledge Counsel indicated, it really is a state version with some changes from a 1983 action. But I'm aware other states have done this. Senator Baruth, your question on subsection D, without weighing in on whether some judge could look at it and say, oh, this is separation of powers issues, I think that Ledge Counsel is right on target. And that is, it is helpful at times for legislative intent for the courts to understand that if there is a question, what is the legislative intent? And this clearly identifies for the courts what the legislature would like us to look to for guidance as far as here is what we, the legislature, intended in enacting this bill. As far as impacts on the courts, While there could be cases that come in and certainly have impacts, we wouldn't know the numbers of those cases. I would also note that there are provisions under federal law that would allow certain cases to be removed on diversity or federal questions. And so there is not only are there cases that can be brought in our state court under this, but those cases could be removed to federal court. And so that would lessen any burden on the courts. I don't have I'm not opining as to, again, the number of cases that we would have, but I do not see the implementation of this as having an impact on the courts such that we would not be able to address these cases in our business as is necessary.
Thank you. Committee, any questions for Judge Jones? All right, thank you, Judge.
Have a great day, everyone. Take care.
Next up, Falco. I have to step out 2 minutes, but you're in good hand. And Senator Morris here for a second.
Good morning. Thank you for the opportunity to testify. My name is Falco Schilling, and I'm the Advocacy Director for the American Civil Liberties Union of Vermont. I'll start off by saying that the ACLU of Vermont strongly supports this bill because we strongly stand behind the idea that people should have the ability to, have remedies when their rights are violated. That's simply what this is trying to do. On its face and in intent, this bill is looking to close a gap that currently exists within the law. State and local officials are currently held to the standards that are envisioned in this bill. So the goal is not to expand that liability, but to simply create a path for folks to bring those suits in state court, as well as to hold federal officials to those same standards. So when I testified in House Judiciary, I was joined by my colleague from the National ACLU, but we thought that was largely unnecessary at this point in time, just because Legislative Council did such an excellent job walking through the entirety of the bill and the arguments that folks might hear on both sides. So you just have me today, but I will second that I think Legislative Council has given a very strong presentation and outlaid many of the facts and considerations at play in this bill. It is a 2-page bill, so there's not a ton to look at, and it's pretty straightforward, but I can walk through, some of the concerns and why this makes sense. So as you heard, currently, if there are constitutional violations by a federal official, there are limited avenues for remedies. There's a Federal Tort Claims Act, which covers common law courts, and not all violations has a number of different procedural hurdles, which you heard about. And Bivens actions, which is a court-created way to bring suits, but that is, as the court also created that action, it's because of action, they're continually narrowing that. And as we look at the current landscape, there's a real gap, and that's what this bill is trying to address. And that is why we and a number of other legal scholars are advocating for these types of laws. And I want to make sure that a number of the different briefing materials that went to House Judiciary are also sent to this committee. There was briefs submitted by a wide range of different scholars, which I think would be helpful in reviewing the issue and go into more depth than we could present today. So in terms of reviewing these laws, the ACLU has seen them pop up in a number of different places around the country. Just to reference, the other states considering similar bills are California, Colorado, Connecticut, Delaware, Washington, the District of Columbia, Georgia, Hawaii, Maryland, Massachusetts, Minnesota, New York, Rhode Island, Vermont, Washington, and Wisconsin. So as we're looking at these bills that are coming up around the country, the 2 main components we think are essential before the ACLU can endorse any sort of legislation like this is, one, is that it creates a civil liability for violations of the U.S. Constitution, and 2, that it mitigate litigation risk by applying to both state and federal actors. As you've heard, trying to limit this to just federal action actors raises a number of concerns, also raising it to just certain state actors, whether it be federal immigration officials or something like that. The way to best address the constitutionality and potential litigation challenges is to do exactly what the drafters did in HE 49 and have this apply equally to all state and local officials. And we also support the importing of Section 1983 language to try and make that as clear as possible. Also to get at what I believe the drafters' intent was, which is not to create new avenues of liability for state and local officials, but to mirror what exists already. And I think, as Ledge Council stated, there's a likelihood if there are claims brought under this against state and local officials, highly likely those could be removed to federal court as well and proceed as they normally would under Section 1983. And so there were a number of questions on the floor of the House of Representatives as this was debated. I think I wanted to try and address some of, since those are likely questions that might come up here in the Senate. And the number one question that came up was just trying to clarify the scope of who this would apply to. And so just to say, once again, this applies to all state, local, and federal officials acting under the color of law. So that would include things like postal officials and others. But as envisioned in this law, the bar to be able to bring a successful suit is pretty high. Currently under Section 1983, there needs to not only be a constitutional violation, it also has to be clearly established law that the action violated the Constitution, and that a reasonable official in that same situation should know that they're violating the Constitution. So that's a pretty high bar. They get that some of the concerns folks heard about a high volume of suit or frivolous suits, and there's also mechanisms to dismiss suits that are frivolous and without merit. And basically, no one can know exactly what a court might do when they look at these laws, but in the opinion of the American Civil Liberties Union, how this was drafted by Legislative Council, the approach that was taken in this bill sets the state up for the highest likelihood of success in moving forward with this type of legislation. And at this point in time, it does feel like it is necessary to address an existing gap within the law when we see actions, especially by federal officials, which do raise concerns about violations of clearly established constitutional rights. And if they were to happen here in Vermont, and folks felt they had the evidence to prove that, we think those folks should be able to have their day in court and to be able to seek remedies for that, whether that be money remedies or direct violation, or if there's systemic constitutional violations happening, look towards injunctive relief as a way to try and address that as well. So at a high level, the ACLU of Vermont strongly supports this bill, and we hope that you move it forward. And I'd be happy to answer any questions.
Maybe is there any questions? So are you, I know I missed the first part of your testimony, but are you also suggesting that subsection A get reworded to some extent?
The 1983 import section?
Yeah.
No.
No.
I mean, if we were to look for changes in the bill, the two things that I would highlight, that I highlight for the House Judiciary Committee, would be the effective date. We would propose that it be effective on passage, so that it's very clear that once this is in effect, that violations that happen after that date, there would be a remedy available. So that's one thing. And then Section 1983, not within the statute itself, but within other areas of federal law, allows for the collection of attorney's fees on a successful suit. We would propose that the legislature look towards those existing federal laws and import similar opportunities to get attorney's fees within the same constructs under existing federal law. But those are the two suggestions that we offered to the House Judiciary Committee, and but still support this piece of legislation and appreciate the House passage and be happy to work with the Senate as you continue to consider it.
Thank you. Any other questions? Okay, thank you. William?
Good morning, Julio Thompson, Assistant Attorney General and Co-Director of the Civil Rights Unit. I want to echo what Judge Sonate said in his first sentence, which is this is a policy bill. This is not a law that involves the state of Vermont taking any action. The Attorney General doesn't have any enforcement authority, nor does any state agency. And so the AG's office doesn't have, if the law were enacted, doesn't have a role in this. That's an issue that has come up in Illinois, for example, when it passed its version of this, and the government said that it violated principles of federalism. The response of the state of Illinois was that you don't have standing to sue the state of Illinois because the governor, the attorney general can't take any action that a court could enjoin. So I think, when we're thinking ahead about if you would like to pass, this is a matter of policy. strengths and weaknesses of the bill. I think the fact that it doesn't include a state enforcement component, I think is an area where I think already out of the gate, I think we'll see the district court wrestle with that issue. Like, how could you block a state for passing a law that where the state has no enforcement authority? So our role, yes.
So it's a strength or a weakness?
I would say it's a strength of the bill because it's an issue. The state of Illinois has argued, and again, we haven't heard the court's decision because it's early days. But the state of Illinois' argument is that those issues of federalism, that's something that the United States or a federal officer or a federal official could bring up in a case where they're being sued. But for the federal government to to start in proactively and say you can't ever apply this law, they're saying, well, you can't show an injury because the state of Illinois is not suing you right now, and indeed the state cannot sue. The role of the Attorney General's office when we look at bills where we don't have, or the state of Vermont doesn't have an enforcement mechanism, really is to look at how the bill works, to try to get a sense of what the legislature, what motivates the sponsors and the folks who have supported the bill. And then also to identify potential challenges and to see whether there are means of either clarifying the bill so it's more effective to do what the legislature wants, or to defend it from, an external challenge. And so, although this is a small bill, I would say in a way that it's a very large bill, because it opens up a type of litigation at the state, and I would argue mostly federal level, that hasn't existed before. We've heard a lot about Section 1983 that was enacted by Congress in 1871 to provide a mechanism for relief for damages and also injunctive relief against state and federal officials. But in the 155 years since then, Congress has not enacted a law to provide a remedy for constitutional violations by federal officials. And so if this statute were to face a court challenge, one of the questions will be, well, why hasn't Congress acted? And what are the basis for Vermont to assert that Congress was fine with any of the 50 states creating such a right of action against the federal government's employees, which may affect federal operations, both in terms of resources to defend such cases, but also in terms of the effects, if any, on influencing or chilling government discretion. Those are the arguments that have been presented in the Illinois case, and they're ones that we're still examining. And again, we haven't had a decision from the federal district court quite yet, so we don't have the benefit of these being tested in front of a judge so far. What I'd like to do in the time that's provided to me here is kind of fill in a few of the gaps that have been, or flesh out, I should say, some of the points that have been raised before today, so that we kind of have a better context of addressing the bill. Because I would anticipate, although not expect, that there may be further testimony on this, and I think these are some additional points to explore. One is there's been mention of the Federal Tort Claims Act, and that provides a means to obtain damages for negligence or other acts. So I want to talk a little bit about the Federal Tort Claims Act and talk about when Congress has opened the gates to waive sovereign immunity to allow itself to be sued or its employees to be sued for harms to the general public. When they have waived that, how have they waived it, and how does that compare against the bill? Because I think that places in context both, I think, the legal challenges that we can face, and I think the legal challenge to the bill is pretty likely based on the statements by the Department of Justice so far. So the Federal Tort Claims Act was passed right after World War II. It was the first time that the U.S. government Congress had by statute expressly waived the general rule of sovereign immunity that says that you can sue the United States for damages, usually arising out of negligence. So I think about something that's like a postal, a post office truck that, rear-ends your car in a parking lot. Federal Tort Claims Act for that kind of negligence allows for someone who's the person, you have a damaged ride, you gotta have it fixed. You can prove your damages, but you've got to sue the United States. And the Federal Tort Claims Act says, yes, you can do that, but you can only do it under rules that we set in Congress. So there are a lot of rules, and I think they're important because this bill doesn't have a lot of rules. And so I think it is a pretty stark contrast. And the question will be, can states create those rules for the ultimate question, or is that something for Congress to legislate? So the Federal Tort Claims Act, you have 2 years to file your claim about your damaged car, and you have to file it with the post office. You have to file out a form that's called Form 95. When you sign the form, there are provisions in the form reminding you that if you're lying about your claim, you could be fined or you could go to jail. So that's a requirement. You have to sign at the risk of criminal exposure in filing the claim. The post office has a period of time to evaluate the claim. If they deny the claim, you have 6 months to go to court. If you wait 6 months and a day, you're out of luck. As we'll talk about in a second, the statute of limitations for this bill is under Vermont's 3 years. So there's different limitations period. If you go to court, there are limitations. You can't seek punitive damages. Attorney's fees are capped at 20% or 25%, depending if the case is resolved at the claims level or the court level. You can't sue for most intentional torts. So if the claim is that the post office employee did it deliberately, you can't sue, you can't pursue that claim, nor can you pursue the claim if the facts would show that the postal employee was exercising their discretion as a federal employee. And there's most of the litigation under the Federal Tort Claims Act is focused on whether federal employees are exercising their discretion. That becomes relevant when we're talking about cases involving law enforcement, because law enforcement officers use a lot of discretion. So at bottom, there are a lot of limitations under the Federal Tort Claims Act. And in 1988, Congress amended the law again to say that if you sue an individual, like the letter carrier who damaged your car, the United States can step in as the defendant so that there's no personal exposure by the letter carrier and then defend the case on behalf of the United States. There is an exception in that act called the Westfall Act for constitutional claims. I'm going to talk about the mechanism for constitutional claims in a second. But in H849, there are quite a few differences between what happens under this bill than what would happen in my letter carrier case. So suppose, for example, that I know the letter carrier, he's my letter carrier, and he damages my car, but I claim that he either did it negligently or, because you can plead, you can sue in the alternative, or he did it intentionally in retaliation for me complaining about how late he delivers the mail. And that claim is a claim of First Amendment retaliation. I exercise my First Amendment right to make a grievance to the government. Dear supervisor, my letter carrier is not very good. My mail arrives late and sometimes damaged. And my allegation is that the person intentionally backed into my car to punish me for exercising my First Amendment rights. Now, the negligence claim has to proceed under the Federal Tort Claims Act. Congress has said so. But H849 would say I can sue you not by making a federal claim or going to federal court, but I can sue you in state court. And I have 2 years to file the negligence claim, but this bill says I have 3 years. Other states, it's 3 years for personal injury. That's how you establish like your statute of limitations for a constitutional violation. Maine has a 6-year statute of limitation. I think Missouri has a 5-year statute of limitation. And so one of the challenges that we're wrestling with, we're still analyzing it, is one of the vulnerabilities of the bill that you could have 50 versions of this with 50 different statutes of limitation, which are different than the one that Congress created. Would courts be hostile or receptive to that? Because ultimately, this has to be challenged in front of a court. And so now I want to pivot slightly to federal court doctrine that's been alluded to but not really explained, which is the so-called Bivens action. So in 1971, some federal drug enforcement agency agents entered an apartment of a Brooklyn resident, Webster Bivens, and allegedly pointed the weapons at him, forced him to the ground in front of his family, handcuffed him and arrested him, all unconstitutionally, he argued. And he sued in federal court. There was no statute that says that you could sue for a federal constitutional court, but the Supreme Court at that time, an opinion authored by Justice Brennan, said, well, courts are in the job of adjudicating controversies between parties, and the Constitution confers important rights. And so even though Congress hasn't spoken, we think courts have the inherent power to hear such a case. And so we'll allow Mr. Bivens to proceed. So it's kind of a common law remedy that was created by the federal court. There had been a history of federal common law in US history. But that was the first time it really had been applied to a constitutional claim. Since 1971, the US Supreme Court has only allowed that to happen 2 other times. One case involved a congressional employee, female, who claimed sex discrimination by a member of Congress, and the court said you could proceed with a constitutional claim there. And the other instance was a case where someone in a correctional facility was known to have asthma, was not provided access to his asthma medication, and tragically died in custody. And the Supreme Court said you could proceed with an 8th Amendment claim for indifference to the welfare of people in custody under the 8th Amendment's prohibition against cruel and unusual punishment. Since that time, the U.S. Supreme Court, that was in 1983, I think, the U.S. Supreme Court has repeatedly refused to extend remedies for constitutional violations. And indeed, in the most recent decision from a few years ago, the current court has said if we had to, in a majority opinion, if we had to decide Bivens all over again, it's not clear we would do it. Far from it. And in denying these cases, and they're various different cases. So one case, that most recent case involved the owner of a motel near the Washington-Canadian border who claimed that a Customs and Border Protection agent retaliated against him when he complained about excessive force when he was trying to inspect the premises for people who were undocumented. And the motel owner says, I complained about that to the supervisor, and then the agent, called the IRS and had them audit me. So it was a First Amendment retaliation claim. Although there were differing opinions in the justices about why that motel owner could not enforce the claim, the Supreme Court did rule 9-0 effective. There were 9 votes saying you cannot pursue your First Amendment claim. One of the concurrence and partial dissents that was authored by Justice Sotomayor said, there are several million federal employees, and First Amendment claims can be complicated because it involves the intent of the actor who's accused of wrongdoing. And that could be pretty disruptive to government operations. So we think this is an area where Congress really needs to balance the interests in constitutional remedies versus the potential disruption in the workforce. And so that's the context in which these cases fall. Repeatedly, when the Supreme Court has declined to extend a common law remedy, they repeatedly said that these present issues that are best left to Congress. Some of the cases have involved, for example, issues of foreign policy and national security. One case in 2020 involved a border immigration official who shot across the border and killed a 15-year-old boy standing on Mexican soil, Mexican national. And Supreme Court declined, even though they had previously recognized Fourth Amendment claims, they didn't recognize it in that case because they said, whoa, that's really complicated. There's a dispute with Mexico about who's accountable for that. And border also involves national security issues, and that's not for a court to decide. That's for Congress to decide. The big question here for states is, with Supreme Court looking here, be comfortable with states deciding that issue as opposed to Congress. That's the big unanswered question. And so when we look at the bill, there are two sides of the bill. One is actions against federal officers, and the other actions against state and federal employees. And so the question is, if the legislature wants to address all federal employees, how do they do that? And what testimony should they consider to balance what the statute of limitations should be, for example? Should it be different or should it be the same as a federal court claimant? Or should it be narrower? Should the bill only focus on law enforcement employees? There are states looking at similar statutes, but there's also a bill in Congress. Yeah, it's in Congress, it's in both houses, that provide the constitutional remedy, but only for federal law enforcement employees. That's a bill. The bill was introduced last December by Alex Padilla from California. Senator Padilla was also the co-sponsor of that narrower bill is Bernie Sanders. So that's a question that I think in terms of policy that to consider. Our office doesn't have a position on those policy choices, but we want you to be aware of what's being considered out there. And so one bill that's in both chambers is looking at a narrower scope. And the other question is, what happens if a court strikes down the federal part of the bill? Does the legislature want the state part of the bill or not? Generally, part of a statute struck down, courts try to salvage the rest. That's called a doctrine of severability. You sever the unconstitutional part and you keep this part. And the question is, if the state and local part of the bill simply mirrors what happens under Section 1983, does the legislature even want the bill? And for state and local, if it's identical, because if you sue in Superior Court and you allege a local police officer violated the Fourth Amendment of the U.S. Constitution, that's immediately removable to federal court because there's a federal claim in the complaint in violation of a federal law. And it's not clear how that's different than an existing Section 1983 action. And so I think that would be an area for testimony to hear about, like, what benefits does Vermont realize if only the state and local part survives? And if it doesn't, if there aren't any benefits, is there something you want to do about that? To say if it either all survives or none of it survives? That's a policy question. I think that's important. I'll stop there. I know I heard the chime.
Yeah, no problem. Well, thank you for your testimony. Okay. Yeah. All right. We can.